January 15th, 2023, 3 in the morning. A 19-year-old college student stumbles onto Burbank Drive in Baton Rouge, Louisiana. Less than 10 minutes later, Madison Brooks is dead, hit by a car. But that wasn't the beginning of her nightmare. It was the end. This is the story of what happened in the hours before. A story about consent that couldn't be given, justice that's still being fought for, and a system that keeps failing women. I'm your host, and this is Accused. Madison Brooks was a 19-year-old sophomore at Louisiana State University. She was from Madisonville, Louisiana, a quiet community across Lake Pontchartrain from New Orleans. She had attended St. Scholastica Academy, a Catholic all-girls school. Madison was a member of the Alpha Phi sorority, specifically the Delta Tau chapter at LSU. Her university president called her an amazing young woman with limitless potential. Her sorority sisters would later say she died a hero because she donated her heart and kidneys before she passed. Think about that for a second. Even in her final moments, Madison was giving to others. Madison was real. She posted on social media. She studied for exams. She went to bars with friends like any other college student. She was somebody's daughter, somebody's friend. And on the night of January 14th, 2023, she went out to Reggie's bar in Tigerland, which is the social and party area near the LSU campus. Tigerland is a strip of bars and clubs that sits just off campus. Students know it well. But it also has a darker reputation. Poor lighting, no sidewalks, a history of violence. That night at Reggie's, 4 men were also there. Kyvon Washington, 18 years old. Desmond Carter, who was only 17 at the time. Everett Lee, 28. And Kaysen Carver, 18. None of these men were LSU students. According to police records, surveillance video from inside the bar shows Madison and the 17-year-old hugging and dancing together. They didn't know each other before that night. Around 1 in the morning, video from inside Reggie's shows Madison stumbling. She needed help to get back on her feet. Around 1:49 in the morning, she left with all 4 of these men. At 1:54 in the morning, the group got into a vehicle outside the bar. Madison didn't know any of them before that night. But she was drunk. Dangerously drunk. And she asked for a ride home. Here's what we know from the arrest documents. Kaysen Carver was the driver. On January 16th, the day after Madison died, Carver went to the East Baton Rouge Parish Sheriff's Office at 6:10 in the evening. He waived his right to an attorney and agreed to give a statement to police. He told investigators that he and his friends had gone to Reggie's on January 15th. He admitted that they all drank alcohol even though 3 of them, including Madison, were underage. Carver said he didn't know Madison and had never seen her before that night. Carver told police that Madison was very unstable on her feet. She couldn't keep her balance. She couldn't speak clearly without slurring her words. The bar was closing, and Madison asked for a ride home because she was drunk and didn't know where her friends were. Carver said he agreed to drive her because he didn't want to leave her alone while she was that drunk. Think about that statement. He said he didn't want to leave her alone because she was so intoxicated. He recognized that she was vulnerable. Madison got into the car. Washington and Carter got into the back seat with her. Lee sat in the front passenger seat. Carver drove. According to what Carver told investigators, Madison had trouble telling them where she lived. When he asked her for her address, she fell over and couldn't answer him. She literally could not stay upright in the car. She couldn't tell these men where she lived. She was falling over. So instead of taking her to a hospital or calling for help, or even just parking the car somewhere safe and waiting for her to sober up, Carver drove to a nearby street and parked. What happened next is at the center of this entire case. Carver told police that he heard the 17-year-old ask Madison 5 times if she wanted to be intimate with him. He said she gave verbal consent. Then Washington also asked multiple times, and again, Carver said she consented. Carver and Lee stayed in the front seat during both encounters. At one point, Carver said he told his friends they needed to stop and leave. When investigators asked Carver if he thought Madison was too drunk to consent, he said, and I'm quoting directly from the arrest report, "I guess. Let me be very clear about something." Madison's blood alcohol level when she was admitted to the hospital was 0.319%. Later, when the coroner's office did their final toxicology results, they measured it at 0.282%. There's a difference because your blood alcohol continues to metabolize after death. But both numbers tell the same story. Madison was dangerously, life-threateningly drunk. 0.319 is nearly 4 times the legal limit for driving. According to research from the University of Notre Dame, A blood alcohol level between 0.250 and 0.399 indicates alcohol poisoning and loss of consciousness. The National Institutes of Health says blood alcohol levels above 0.31 can be life-threatening. Levels from 0.16 to 0.30 indicate severe impairment. Under Louisiana law, third-degree rape occurs when someone is incapable of resisting or understanding the nature of the act because of a stupor or abnormal condition caused by alcohol, and the offender knew or should have known about that incapacity. Madison couldn't walk straight. She couldn't speak without slurring. She couldn't tell them where she lived. She fell over when they asked her for her address. And yet, 4 men got her into a car, and 2 of them, according to prosecutors, committed acts that led to criminal charges. Kevin Washington also gave a voluntary statement to police. He told investigators that Madison was, and this is a direct quote from the affidavit, "Like when I tell you drunk, she was drunk." Washington's own words confirm that Madison was extremely intoxicated. He said that while in the back seat, his 17-year-old friend and Madison touched each other's private areas, but he denied witnessing them have intimate contact and denied having intimate contact with Madison himself. Washington also confirmed that Carver left Madison at a subdivision near the crash scene. Everett Lee also gave a statement. He told investigators he was seated in the passenger seat and in the vehicle with Madison and the other 3 men, but he didn't provide further details. On January 18, 2023, 3 days after Madison died, an autopsy was conducted. The forensic pathologist reported that Madison had injuries consistent with the allegations in the case. The autopsy also found that Madison had tested positive for THC, the main psychoactive compound in marijuana. Shane Evans, the chief of investigations for the East Baton Rouge Parish Coroner's Office, said that Madison died from multiple traumatic injuries secondary to motor vehicle collision versus pedestrian. In other words, she died from being hit by the car. After the alleged incidents, the men couldn't find where Madison lived, so they dropped her off in a neighborhood near Burbank Drive and Pelican Lakes Parkway. It was around 3 in the morning. The area was dark. There were no sidewalks. Madison, stumbling and disoriented and dangerously drunk, walked into the road. At 2:50 in the morning, she was hit by a car. The driver was a rideshare driver who was sober. He called 911 immediately. He stayed on the scene. He did everything right. He was not charged with any crime. 2 good people who were driving by stopped and tried to save Madison's life. They performed CPR until paramedics arrived, but Madison died from her injuries at the hospital. Before she died, she donated her heart and kidneys. Her sorority said she died a hero. 8 days later, on January 23rd, all 4 men were arrested. They turned themselves in to the East Baton Rouge Parish Sheriff's Office. Washington and Carter were charged with third-degree rape. Lee and Carver were charged as principals to rape, which means they were present and knew what was happening but didn't stop it. Under Louisiana law, you can be charged as a principal to a crime if you help facilitate it or if you're present and don't intervene when you could have. On January 24th, the 3 adult suspects appeared for bond hearings. Judge Brad Myers reviewed video footage during the hearing. He said the video showed the suspects callously laughing while Madison slurred her words inside the car. Judge Myers said the evidence was clear that a crime had occurred, but the defense kept pushing their narrative that criminal charges weren't warranted. Washington's bond was set at $150,000. Carver's was $50,000. Lee's was $75,000. By January 26th, both Carver and Lee had bonded out of jail. Washington bonded out on January 26th as well. Later, a grand jury indicted Carter, who was 17 at the time, for first-degree rape. He's being tried as an adult. Washington was also indicted for first-degree rape. Carver was eventually indicted for both first-degree and third-degree rape, plus video voyeurism. The video voyeurism charge came because prosecutors say Carver recorded portions of what happened on his cell phone. Let that sink in. Prosecutors allege that he was filming what was happening to Madison in the back seat. The 4th man, Everett Lee, was arrested, but a grand jury pretermitted on his charges, which means they didn't make a decision. So he hasn't been formally indicted yet. If you're as angry about this case as I am, and you want to keep following stories where justice hangs in the balance, hit that subscribe button. We're not here for clickbait. We're here because these stories matter. Okay, back to Madison. Now let's talk about what happened after the arrests. Defense attorney Ronald Haley, who represents Washington and Lee, told the media that this was absolutely not a rape. He said video from that night shows Madison was intoxicated, but not to the point where she couldn't legally give consent or answer questions. He said she willfully got into the car. He told a local television station that this was a tragedy, definitely not a crime. Another defense attorney, Joe Long, who represents Carver, said this case wouldn't be a crime if Madison was alive. He said she wouldn't have complained about it at all. He said there's understandable anger in the community and people want somebody to pay for her death. But his clients didn't commit a crime. Let me stop right here. The defense attorneys held a press conference where they said that if Madison was alive, this wouldn't be a crime because she wouldn't have complained. That statement puts blame on the victim rather than examining the accused's actions. Kerry Miller, an attorney representing Madison's family, was blown away by that comment. He told Fox News Digital that the defense attorney's clients gave sworn statements about what happened that night with a young woman who was intoxicated. Here's the thing. Being able to walk does not equal being able to consent. The fact that Madison could physically move her body doesn't mean she was capable of understanding what was happening to her or making decisions about her own safety. At a blood alcohol level of 0.319, you're at risk of losing consciousness. You're at risk of alcohol poisoning. Your judgment is severely impaired. Your motor skills are severely impaired. And the law recognizes that. That's why third-degree rape exists in Louisiana. It's specifically for situations where someone is so intoxicated that they can't consent. Judge Brad Myers reviewed video footage during a bond hearing in January 2023. He said the video showed the suspects callously laughing while Madison slurred her words inside the car. He said the evidence was clear that a crime had occurred. But the defense kept pushing their narrative. In March 2024, more than a year after Madison died, defense attorney Joseph Long filed a motion claiming that an unnamed LSU student had consensual intimate contact with Madison the day before she died. The motion used the alias John Snow for this person. Long argued that injuries found during Madison's autopsy actually came from this earlier encounter, not from what happened in the car. He said this testimony would change the state's theory of the case. The motion also mentioned another witness with the alias Haley Cage who allegedly picked Madison up and could testify to this. District Attorney Hiller Moore called the motion totally improper. He said it violated Louisiana's Code of Evidence because it discussed a victim's past intimate behavior, which the law requires to be kept in separate sealed documents. And here's the critical point. Even if this allegation were true, it changes absolutely nothing about what happened in that car on January 15th. Madison's intimate history, whether she had been with someone the day before, or the week before, or never before, has zero relevance to whether she could consent that night when she was dangerously drunk in the back of a car with two men she didn't know. But defense teams often use this tactic. They try to shift blame away from their clients and onto the woman who can't defend herself because she's dead. In March 2025, the First Circuit Court of Appeals ruled that Madison's intimate history could not be used at trial. The court said the evidence of her alleged past intimate behavior is excluded. They said the fundamental right to present a defense doesn't require the trial court to admit irrelevant evidence, or evidence with such little value that it's outweighed by other concerns. District Attorney Moore said his office was pleased with the ruling that would prohibit defendants from introducing overly prejudicial and irrelevant evidence at trial. Now, here's where things get really concerning. In July 2023, Madison's autopsy report was leaked. Details about the DNA evidence in the case were published by local television station WBRZ. According to the leaked autopsy, DNA from none of the four men was found inside Madison in ways that would directly prove the charges. Genetic material from Washington was found in Madison's genital area, but there was no sign of trauma. The autopsy didn't specify whether the DNA was found in bodily fluids or epithelial cells, which are just skin cells. A separate lab report from the Louisiana State Police Crime Laboratory said that material gathered from 13 swabs and 2 washings resulted in insufficient male DNA samples from certain areas. A swab of external genitalia revealed DNA that could have come from Washington, but none of the others. Defense attorney Joe Long said in an email that the autopsy is a game changer. He said they believe the DNA evidence gives them reasonable doubt. He said no reasonable jury will convict after hearing that evidence. He said the state will have a very difficult time proving what happened if there's no DNA in the victim. And even if the state could prove intimate contact occurred, it cannot prove it was not consensual. But legal experts say the lack of DNA doesn't necessarily mean the case is fatally flawed. Kevin Boschia, a defense attorney who spent 10 years handling cases with the Orleans Parish District Attorney's Office, said the autopsy's findings are not necessarily indicative of a fatally flawed case. The lack of DNA could be explained by several factors: condoms, the passage of time, the fact that Madison was in a car accident and received medical treatment before she died. District Attorney Moore sought a protective order to prevent future discovery from being placed in the public record and handed out in a piecemeal fashion. He said the leaks were designed to protect the defendant's ability to present a fair case, but they were taking an emotional toll on Madison's family. Madison's mother, Ashley Boustert, said the leaks were really a low blow. She said there are ups and downs, but it takes an emotional toll on them. She also said this doesn't change anything. A grand jury saw the evidence and still chose to indict. Now let's talk about Reggie's bar, because this place has a history. In 2017, police conducted a sting operation there that led to dozens of citations for underage drinking and minors on the premises. The bar was suspended for 45 days and fined $8,000. But it reopened. Over the years, there were multiple reports of violence at the bar. In 2011, 2 men were attacked outside. In 2014, someone was arrested for attempted murder outside Reggie's. In 2015, 2 drunk men threatened customers and employees with loaded guns. In 2016, an LSU football player was stabbed after a fight at the bar spilled into the street. This wasn't a safe place. It was known for serving underage students. It was known for violence. On the night Madison died, she was 19. She was underage. But according to a wrongful death lawsuit filed by her father, John Brooks, bartenders at Reggie's gave Madison an over 21 wristband even though she was underage. The lawsuit claims she was served 24 drinks that night and fell 4 times inside the bar. Her blood alcohol level later showed she had severely impaired functions, and the lawsuit argues she was visibly intoxicated and shouldn't have been served. 3 of the 4 men she left with that night were also underage. Yet they were all drinking at Reggie's. How did that happen? How does a bar serve alcohol to 4 underage people, one of whom is falling down multiple times inside the establishment? After Madison's death, the Louisiana Office of Alcohol and Tobacco Control issued an emergency suspension of Reggie's liquor license on January 24th. Ernest Legier, the agency's commissioner, cited the seriousness of the allegations and the potential threat to public safety. The suspension remained in place pending a hearing the following month. Later, the bar's liquor license was permanently revoked. The agency determined that the owner and manager were ineligible and unsuitable to hold or manage an establishment with an alcohol permit. Reggie's was also fined $15,000. The bar is now closed. It will never reopen. Madison's father, John Brooks, filed a wrongful death lawsuit in September 2023. The lawsuit names nearly 24 defendants. It includes Reggie's owners, managers, and bartenders. It includes the 4 men arrested in the case. It includes the driver who hit Madison, even though he wasn't charged with a crime. It includes the rideshare company Lyft. It includes various insurance companies. The lawsuit argues that all of these parties were complicit in some way and should be held liable for Madison's death. Her mother, Ashley Boustert, filed a nearly identical lawsuit in January 2024. In April 2024, both civil cases were put on hold while the criminal cases play out. That's standard procedure. The criminal cases need to be resolved first before the civil cases can move forward. Now, there's another layer to this case that's causing serious concern. The judge presiding over some of these cases is Judge Gail Horn Ray, and there are questions about whether she should be on this case at all. In 2022, Judge Ray released a different accused person on reduced bail in a separate case, which raised eyebrows. In 2023, she made an unprecedented decision to vacate a 1972 conviction. She did this during a hearing where the defendant was requesting parole eligibility. She essentially bypassed the parole process entirely and threw out the conviction. District Attorney Moore took issue with that decision. He argued that the judge had access to limited evidence and that the defense had already been presented and rejected in the early 90s. Moore wrote in a court filing that the trial court doesn't possess the inherent authority to ignore proper legal procedures and consider whatever it wants, whenever it wants. But here's what makes this even more complicated. Judge Ray's own son was convicted of multiple counts involving unlawful contact with victims. He pleaded guilty to several incidents that occurred between November 1995 and April 1996. He's serving a lifetime sentence. Judge Ray was actually her son's lawyer when he pleaded guilty. Now, some people might argue that having a son who's serving time would make Judge Ray more sympathetic to victims. But others argue the opposite. They argue it might make her more sympathetic. to defendants because she's seen how the system treated her own son. Judge Ray is also a Silver Life member of the NAACP. She received the Justice for Youth Award from the Juvenile Justice Project of Louisiana and the President's Award from the Baton Rouge NAACP because the defendants in Madison's case are black and Madison was white. The case became racially charged. There were questions of bias on both sides. Some people worried that Judge Ray might be biased in favor of the defendants because of her NAACP membership and the racial dynamics of the case. Others worried that the public pressure and media attention might bias her against the defendants. Madison's mother, Ashley Boustert, has publicly said she doesn't feel confident about Judge Ray being on her daughter's case. Boustert said there have been numerous rulings that had to be overturned by appellate courts. She also said she's not confident in the judge's judgment based on her son's prior convictions. In September 2025, District Attorney Moore filed a motion under seal to have Judge Ray removed from the case. Moore said he hoped the judge would voluntarily recuse herself. His argument was that Judge Ray had initially ruled that certain evidence, specifically evidence about Madison's intimate history, could be used in the trial. But the First Circuit Court of Appeals ruled that evidence couldn't be used. Because the judge had already seen that evidence and thought it was relevant, the DA argued she couldn't be impartial going forward. Her mind had already been influenced by evidence that the jury will never see. Now let me tell you what happened to one of the other suspects, because this is where the story gets even darker. Kyvon Washington, the 18-year-old charged in Madison's case, was arrested 2 more times after Madison's death. Just days after he bonded out of jail in Brooks' case, a 12-year-old girl came forward. She said that Washington committed a crime against her in 2020 when he was 16 and she was 12. She told her story to a local journalist at Unfiltered with Kieran. The girl said she had been at a pool party in Walker, Louisiana, when she and a friend went back to her apartment. Washington and another boy followed them. She described what happened to her in that apartment. The girl had actually reported this to Walker police in March 2021, almost a year after it happened. But the police didn't thoroughly investigate. They said the stories from Washington and the victim didn't match, so the case hit a dead end. It wasn't until Washington was arrested in Madison's case that the police reopened the investigation. A witness came forward and corroborated details about the alleged incident. On January 27, 2023, Washington turned himself in to the Livingston Parish Detention Center. He was charged with first-degree rape because the victim was under 13 at the time. A Livingston Parish grand jury indicted him on May 17, 2023. The 12-year-old victim spoke publicly about why she came forward. She said, "If you've been harmed by Kyvon Washington, I want you to know that you're not alone. I know it's hard, but if you speak up, hopefully he will get put in jail forever and we will get justice. Not only for Madison Brooks, but for all of us that he has done this to." She also said she feels like if Walker police had listened to her when she first reported it in 2021, Madison Brooks would never have been in that situation. But it doesn't stop there. In February 2023, Washington was charged with yet another crime. This one allegedly happened in October 2022 at Reggie's bar, the same bar where Madison was. A woman said she was at Reggie's for a birthday party when she had multiple alcoholic drinks. She ran into an acquaintance named Carson Jones and some of his friends in the parking lot. Washington was in that group. The woman told Jones she was too drunk to drive home, so she asked if she could stay at his place. Jones said yes, but then according to the arrest warrant, events took place that led to criminal charges against both men. According to the arrest warrant, Jones grabbed the woman's face and held her mouth open as Washington poured a drink down her throat. Then Washington allegedly participated in acts that led to charges. Afterward, Washington apologized to the woman in a text message. The woman showed police these text messages where Washington apologized and admitted to touching her, but he blamed Jones for grabbing his hand and pulling it toward her. Jones admitted to police that he had intimate contact with the woman and that Washington walked over to the bed while they were having such contact. Both Washington and Jones were arrested and charged with first-degree rape in this case. Washington was indicted on May 17, 2023. So let's be clear about what we're looking at here. Kyvon Washington is charged with third-degree rape in Madison Brooks' case. He's charged with first-degree rape in the 2020 case involving a 12-year-old. And he's charged with first-degree rape in the October 2022 case at Reggie's bar. That's 3 separate allegations. 3 separate women, and the pattern is concerning. The October 2022 case followed a nearly identical pattern to Madison's. A woman met Washington at Reggie's bar. She was too drunk to drive and asked to sleep somewhere safe. Alcohol was used as a tool. Multiple men were involved. The woman was separated from her friends. Defense attorney Ron Haley, who represents Washington, has said his office was just made aware of additional allegations and they're in the process of investigating. But he's also raised questions about the timing. He said it's very odd and suspicious that these cases suddenly have probable cause for arrest when they didn't before. He's implying that prosecutors are piling on charges because of the publicity around Madison's case. But here's the thing. Victims of these crimes often don't come forward immediately. They're scared. They're ashamed. They don't think anyone will believe them. And when they do come forward, police don't always take them seriously. The 12-year-old girl reported her case in 2021, but Walker police didn't investigate thoroughly. It wasn't until Washington was arrested in Madison's case that the police went back and did a proper investigation. That's not suspicious. That's a failure of the system to protect victims. So where does this case stand now? As of late 2025, Casson Carver is scheduled to go to trial on December 1st, 2025. He waived his right to a jury trial in September, which means a judge will decide his fate instead of a jury. He's charged with first-degree rape, third-degree rape, and video voyeurism. If he's convicted of first-degree rape, he faces life in prison without the possibility of parole. His lawyer, Joseph Long, maintains that Carver never touched Madison Brooks. Long says Carver turned down an opportunity to be intimate with Madison and is still being charged. But District Attorney Moore says more than one person can be charged in a case like this. It's not only the person who causes direct harm, but others who assist in the act. Under Louisiana law, if you help facilitate a crime or if you're present and don't intervene when you could have, you can be charged as a principal to the crime. And here's something important to understand. Testing showed that none of the 4 suspects' DNA was found inside Madison Brooks in ways that would directly prove the charges. That's going to be a major challenge for prosecutors. But the lack of DNA doesn't mean nothing happened. It just makes the case harder to prove. There are several reasons why DNA might not be found. If condoms were used, there wouldn't be DNA. If enough time passed between the alleged incident and when the samples were collected, DNA could have degraded. Madison was in a car accident. She received medical treatment. All of that could affect whether DNA is found. But prosecutors still have other evidence. They have Madison's blood alcohol level, which proves she was incapable of consenting. They have the autopsy findings that show injuries consistent with the allegations. They have the statements that Carver and Washington gave to police. And they have video footage from inside the car. Desmond Carter and Kyvon Washington also have court appearances scheduled. Their cases are moving more slowly. Carter's attorneys appealed the decision to exclude Madison's intimate history from trial. The Louisiana Supreme Court is reviewing that issue, and the outcome will impact Carver's case too. As of now, no trial dates have been set for Carter or Washington. Washington remains in custody because of his other pending charges. He's being held in Livingston Parish on a $250,000 bond for the 2020 case. He also faces charges in the October 2022 case in East Baton Rouge Parish. Let's zoom out for a second. This case highlights something much bigger than what happened to one young woman, as tragic as that is. Experts say Madison's case shows the dangers women face, especially in Louisiana. The state has some of the highest rates of crimes against women in the country. But Madison's case got national and international attention because she was white, middle class, and attending a well-known university. She fit a certain profile that the media pays attention to. Many victims, especially women of color and women from lower economic backgrounds, don't get this kind of coverage. Their cases don't make headlines. Their names don't trend on social media. Their attackers don't get arrested. But their pain is just as real. Their trauma is just as valid. Morgan Lamondre is the president and CEO of STAR, which stands for Sexual Trauma Awareness and Response. It's an organization that offers court representation and other resources to survivors across 15 Louisiana parishes. Lamondre said that of every 1,000 cases of this nature, only 50 yield arrests according to data compiled by RAIN, which is a national group that advocates against such violence. That's 5%. 95% of these cases don't result in an arrest. The fact that prosecutors are seeking charges against 4 people in Madison's case suggests that investigators built an unusually strong case. But it also raises the question, why don't we see this kind of response for other victims? And then there's the bigger conversation about consent. If someone is too drunk to walk straight, they're too drunk to consent. Full stop. The burden should never be on the victim to prove they said no. The burden is on the other person to make sure there's an enthusiastic, informed yes. And if there's any doubt if the person is slurring their words, falling over, unable to tell you where they live, then the answer is no. You don't engage in intimate contact with them. You don't put them in a car and drive them somewhere isolated. You make sure they get home safely. You call their friends. You call an ambulance if they're dangerously drunk. You do the right thing, but that's not what happened to Madison. 4 men saw a woman who was dangerously drunk and, according to prosecutors, decided to take advantage of her vulnerability instead of protecting her. And when they couldn't figure out where she lived, they dropped her on the side of a dark road in the middle of the night and drove away. They left her there to stumble into traffic. They left her there to die. Tigerland, where Reggie's bar was located, is notorious. Students and locals have described it as an area with poor lighting, no sidewalks, and a lot of crime. After Madison's death, LSU President William Tate called for accountability. He sent an email to students on January 23rd, the day the arrests were announced. He said Madison was an amazing young woman with limitless potential. She should not have been taken from us in this way. What happened to her was wrong, and our legal system will handle justice. But then Tate focused most of his statement on underage drinking. He said 3 of the 4 suspects were underage, yet were able to consume alcohol at a local bar. He said the university's action plan starts with a deep and relentless focus on any establishment that profits off students by providing alcohol to underage individuals. He said they would call a meeting with business owners to discuss how their responsibilities directly impact the safety of students. But many students and advocates said that response missed the point. LSU College Democrats and Feminists in Action released a joint letter criticizing Tate's statement. They said the individuals were arrested for third-degree rape and principal to rape, not underage drinking or driving under the influence. They said the only conclusion to draw is that the accused are to blame for what happened to Madison. The student group said they were troubled by what they called an attempt to shift focus away from the criminal allegations and further ignore the overwhelming violence, particularly violence of this nature that students face. They said Tate chose to reinforce problematic attitudes on campus and in the greater East Baton Rouge community. While students were grieving the loss of their peer and fearing for their safety and well-being, the administration directed its attention to the underage consumption of alcohol. The group said this response was not acceptable. Morgan Lamondre from Star said it plainly. Alcohol did not cause Madison's harm or her death. The perpetrators caused her harm, which led to her being in a place that ultimately led to her death. She said that after the tragic events surrounding Madison Brooks, community conversations almost entirely revolved around alcohol and underage drinking. She said LSU has seen several student deaths related to alcohol poisoning and hazing, but blaming her death on alcohol is a misguided deflection tactic. Had Madison been given a ride home by anyone other than the accused, she likely would have been brought somewhere safe and still be alive today. Lamondre said that alcohol is never the cause of these crimes, but a way that perpetrators facilitate them. Marissa Eisworth, a junior at LSU and the president of Feminists in Action, said Tate's statement seemed to blame Brooks for the events of that night. Students said they were terrified for their own safety, terrified that LSU didn't seem to care about the issues they were facing. One student told the LSU student newspaper The Reveille that he was terrified for the safety of his peers, terrified for his own safety, and terrified that LSU doesn't seem to care about the issues students are facing. Another student said that while she appreciated Tate acknowledging Madison's death, his statement felt like it was blaming the victim, and they pointed out that LSU has a troubled past with how it handles these situations. In 2021, student organizations called for the removal of a French professor named Edwige Crucifix, who allegedly ignored complaints of this nature while she was department chair. Students organized protests. They demanded accountability. The administration didn't respond in any meaningful way. Crucifix remained in her position. That sent a message to students. It told them that the administration didn't take these issues seriously. It told them they were on their own. After Madison's death, students organized vigils and protests. Hundreds of students gathered on LSU's parade ground to honor Madison's memory. They lit candles. They shared stories. They demanded change. One vigil was organized by LSU College Democrats and Feminists in Action. Students held signs that said things like, "Protect women" and "End rape culture." They chanted Madison's name. They cried. They hugged each other. And they demanded that LSU do better. Ashley Boustert, Madison's mother, attended some of these vigils. She spoke publicly about her daughter. She said Madison was her baby girl. She said Madison had a beautiful smile and a kind heart. She said Madison wanted to be a lawyer. She wanted to help people. And now she would never get that chance. Boustert has been fighting for justice ever since. She posts on social media about the case. She attends court hearings. She speaks to reporters. She refuses to let people forget her daughter. In September 2023, Madison's family established the Madison Brooks Foundation. The foundation's mission is to raise awareness about these crimes and to support survivors. They want Madison's legacy to be about helping others. They want something good to come from this tragedy. The foundation has partnered with STAR to provide resources to survivors. They've organized events to raise money and awareness. They're trying to turn their grief into action, but the fight for justice has been long and painful. It's been almost 3 years since Madison died, and there still hasn't been a trial. The delays have been excruciating for Madison's family. Every time there's a court hearing, they have to relive the trauma. Every time the defense files a motion attacking Madison's character, they have to read those accusations. Every time evidence gets leaked to the media, they have to see the most intimate details of their daughter's death splashed across the news. Ashley Boustert has said that the legal process has been harder than she ever imagined. She thought there would be quick justice. She thought the evidence was clear. But the reality is that criminal cases, especially cases of this nature, move slowly. Defense attorneys file motions. Judges rule on those motions. Appeals get filed. Evidence gets challenged. And through it all, the family waits. One of the most painful aspects has been the attempts to blame the victim. Defense attorneys have tried repeatedly to paint Madison as somehow responsible for what happened. They've argued that she willingly got into the car. They've tried to introduce evidence about her intimate history. They've implied that she was too drunk to remember what happened, so how could criminal charges be justified? But here's the thing. Madison didn't need to remember what happened for it to be a crime. The law doesn't require a victim to be conscious or aware during an incident for it to be criminal. In fact, that's the whole point of third-degree rape laws. They exist specifically to protect people who are incapacitated. And let's talk about this idea that Madison willingly got into the car. Yes, she asked for a ride home. She was drunk and didn't know where her friends were. She needed help. But asking for a ride home is not consent to intimate contact. Getting into someone's car is not consent to intimate contact. Even if Madison had flirted with these men at the bar, even if she had kissed one of them, even if she had expressed interest, the moment she became too drunk to understand what was happening, any prior consent was invalid. You cannot consent when you're incapacitated. That's the law. The defense has also tried to argue that Madison verbally consented in the car. According to Carver's statement, the men asked her multiple times if she wanted to be intimate, and she said yes. But here's what the defense doesn't want to acknowledge. A person who is falling over, slurring their words, and unable to tell you where they live is not capable of giving meaningful consent. Even if Madison said yes, even if she said it multiple times, she was too drunk to understand what she was agreeing to. Her words don't matter when her brain is shut down by alcohol. Think about it this way. If someone is blackout drunk and you convince them to sign over their house to you, that contract isn't valid. If someone is blackout drunk and you convince them to give you all their money, you can be charged with theft. The law recognizes that people who are severely intoxicated can't make legal decisions. So why would we treat intimate consent any differently? Why would we say that a person who's too drunk to sign a contract is somehow capable of consenting to intimate acts? There's also been a lot of discussion about the role of bystanders in this case. Everett Lee and initially Casson Carver were charged as principals because they were present and didn't intervene. Lee was in the front passenger seat. Carver was driving. According to Carver's own statement, he could hear what was happening in the back seat. He knew Madison was extremely drunk. He knew his friends were engaging in intimate acts with her, and he didn't stop it. He didn't tell them to stop. He didn't drive to a police station. He didn't call for help. He just kept driving. Louisiana law says that you can be charged as a principal to a crime if you're present and you assist or encourage the crime, or if you fail to prevent it when you have a duty to do so. The question in this case is whether Lee and Carver had a duty to intervene. Prosecutors argue that they did. They argue that when you see someone being victimized, you have a moral and legal obligation to stop it. You don't get to just sit there and watch. You don't get to drive the car while your friends take advantage of someone in the back seat. Defense attorneys argue the opposite. They say their clients didn't have a duty to intervene. They say that under Louisiana law, you can only be charged as a principal if you actively assist in the crime. Simply being present isn't enough. This is going to be a major issue at trial. If the jury or judge believes that Lee and Carver had a duty to intervene and failed to do so, they could be convicted. If not, they could walk free. But even if they're acquitted of the criminal charges, the moral question remains. What kind of person sits in a car and listens to their friends take advantage of someone and does nothing? What kind of person drives away and dumps a drunk woman on the side of a dark road? Now let's talk about the broader context of these crimes in college settings. According to RAIN, 11.2% of all students experience rape or similar violations. For undergraduate students, the rate is even higher. 13% of undergraduate women experience these crimes. That's more than 1 in 10. And those are just the cases that get reported. Most cases are never reported to police. Survivors don't report for many reasons. They're afraid they won't be believed. They're afraid of retaliation. They're afraid of the legal process. They're ashamed. They blame themselves. And when survivors do report, the system often fails them. RAIN says that out of every 1,000 such incidents, only 50 result in arrests and only 25 result in incarceration. That means 97.5% of perpetrators walk free. They never face consequences for what they did. And that sends a message. It tells potential criminals that they can get away with it. It tells survivors that coming forward isn't worth it. College campuses are particularly dangerous for women. The combination of alcohol, parties, and young people who are away from home for the first time creates a perfect storm. Predators know this. They know that college parties are target-rich environments. They know that if they can get a woman drunk enough, they can take advantage of her, and she probably won't remember enough to report it. And even if she does report it, there's a good chance she won't be believed. She'll be accused of regretting consensual contact. She'll be accused of crying foul because she's embarrassed. She'll be accused of ruining a young man's life over a misunderstanding. This is rape culture. Rape culture doesn't mean that everyone commits these crimes or that everyone supports them. It means that we live in a society that minimizes this violence, blames victims, and protects perpetrators. It means that when a woman is victimized, the first questions are about what she was wearing, how much she had to drink, and whether she fought back hard enough. It means that men who take advantage of drunk women at parties are called promising young men who made a mistake instead of criminals. It means that universities care more about protecting their reputation than protecting their students. LSU has faced criticism for years about how it handles these situations. In 2019, a lawsuit alleged that LSU deliberately ignored allegations against football players because the university didn't want to hurt the team. The lawsuit said that LSU discouraged students from reporting, and that when they did report, the university failed to investigate properly. LSU settled that lawsuit, but they didn't admit wrongdoing, and the problems continued. After Madison's death, students demanded that LSU implement better safety measures. They wanted more lighting in Tigerland. They wanted better transportation options so students wouldn't have to rely on strangers for rides. They wanted mandatory prevention training that actually worked. They wanted the university to take rape culture seriously. Some of these demands have been met. LSU has increased lighting in some areas. They've expanded their Safe Ride program. But students say it's not enough. They say the university is more interested in public relations than actual change. And here's the uncomfortable truth. No amount of lighting or Safe Ride programs will stop these crimes. Because these crimes aren't caused by dark streets or lack of transportation. They're caused by perpetrators. They're caused by men who see drunk women as opportunities instead of human beings. They're caused by men who think that if a woman is too drunk to say no, that means she's saying yes. They're caused by a culture that teaches men they're entitled to women's bodies. And until we address that root cause, women will continue to be victimized. So what needs to change? First, we need to change how we talk about consent. Consent isn't just the absence of a no. It's the presence of an enthusiastic yes. Consent isn't something you assume. It's something you get. And consent can be withdrawn at any time. If someone is too drunk to walk straight, they can't consent. If someone is unconscious, they can't consent. If someone is scared, they can't consent. This should be basic common sense, but clearly it needs to be taught. Second, we need to hold perpetrators accountable. Not just in high-profile cases like Madison's, but in every case. When someone reports one of these crimes, police need to investigate thoroughly. Prosecutors need to take these cases seriously. Judges need to impose meaningful sentences. And universities need to expel students who commit these acts. We can't keep letting criminals off with a slap on the wrist and then act surprised when they offend again. Third, we need to stop victim blaming. When someone is victimized, we need to stop asking what they were wearing or how much they had to drink. We need to start asking why the perpetrator thought it was okay to harm someone. We need to shift the focus from the victim's behavior to the perpetrator's choices. Because the victim didn't cause the crime. The perpetrator did. Fourth, we need to support survivors. That means believing them when they come forward. It means providing resources like counseling and legal advocacy. It means creating a system where survivors can report without fear of being re-traumatized. Organizations like STAR are doing incredible work in Louisiana, but they're underfunded and overwhelmed. We need to invest in these services. And fifth, we need bystander intervention. If you see someone who's too drunk to consent, step in. Get them away from the situation. Make sure they get home safely. Don't just watch and do nothing. And if you see your friends behaving in ways that are predatory or harmful, call them out. Don't laugh it off. Don't make excuses. Tell them that what they're doing is wrong. Because silence is complicity. As I record this, Madison Brooks would have been 21 years old. She would have been finishing her junior year at LSU. She might have been studying for the LSAT, planning for law school. She might have been at a sorority formal or a football game. She might have been calling her mom to tell her about her day. But she's not here to do any of those things. Because on January 15th, 2023, 4 men made a choice. They chose to take advantage of a young woman who was dangerously drunk. They chose to engage in acts that led to criminal charges. And they chose to abandon her on a dark road where she was hit by a car and killed. Madison's mother, Ashley Boustert, continues fighting for justice. She posts on social media. She attends court hearings. She speaks to reporters. She refuses to let people forget her daughter. In one interview, she said that she wakes up every day and has to remember that Madison is gone. She said there are good days and bad days, but the bad days are really bad. She said she feels like the justice system has failed Madison over and over again. The delays, the leaks, the victim blaming, all of it has taken a toll. But Boustert also said she's not going to stop fighting. She said Madison deserves justice. She said all survivors deserve justice. And she said if telling Madison's story can help even one person, then it's worth it. That's the kind of mother Madison had. Someone who loved her so much that even in the depths of grief, she's trying to help others. The Madison Brooks Foundation continues its work. They've raised money for STAR. They've spoken at events about prevention. They've kept Madison's memory alive. And they've made sure that Madison isn't just remembered as a victim, but as a whole person. A daughter, a friend, a sorority sister, someone with dreams and potential and a future that was stolen from her. This case isn't over. Cass and Carver's trial is set for December 1st, 2025, but it could be delayed again. Carter and Washington's trials haven't been scheduled yet. The civil lawsuits are on hold. Justice, if it comes at all, is still a long way off. But one thing is crystal clear. Madison Brooks was failed. She was failed by the bar that gave her an over 21 wristband when she was 19 and served her alcohol when she was visibly intoxicated. She was failed by the men who saw her vulnerability and, according to prosecutors, exploited it. She was failed by the men who dumped her on the side of a dark road and drove away. And she's being failed by a justice system that's taking years to bring her case to trial while defense attorneys attack her character and leak evidence to the media.